Well, thank you all for coming to our second annual lunch with Gutman. See if I can get that heat back down a little bit. I'm Dave Summers, Executive Director of the Omaha Bar Association, and I appreciate you all coming out on the day after the longest day of the UN address. Might have been bad scheduling on our part to have a conversation about federal campaign financing on the day after the State Union because of the late nights. But I did want to tell you that this has been approved for CLE credit in Nebraska. Iowa's always slow. I seen the bill give us credit. If Daniel goes long, we'll ask for more credit. And I will email everybody the credit information afterwards. So you have the information and you can get your proper CLE credit. Daniel's following Lunch with Fenner, which was like 30 lunches and breakfasts, a few breakfasts over 31 years by Professor Mike Fenner of Creighton Law. Kathleen Pallison, our president this year, she wanted to give some love to Nebraska, so she was pushing for somebody from Nebraska College of Law, and you have Daniel here to try to follow in those footsteps of Mike Fenner on talking big constitutional issues in the middle of winter, or maybe the end of winter. We have to know. Judge Battalion was on the list today, but I don't see him in the room. I do want to recognize Judge Caparelli, who is here. Judge he's been in practice 69 years, and was the Barristers Club president, Omaha Barristers Club president, back in 1959. Joe Battalion was Barristers president, but is only in 82, so he's a newbie comparatively. As we're going through the history of the 150th year of the Omaha Bar Association, we just found a lot of interesting long-standing connections. The Barristers Club actually goes back to 1912 when it was started. The gridiron dinner roasting judges started in quickly in 1913. That they started the dinner that we now know as the Christmas show for the barristers. Here at Field Club, our first field day as the Omaha Bar Association was in 1910. We had a reception in not this building, but the building that preceded the last building here at Field Club. That was our first field day to reception. Our second day golf tournament was here at Field Club in 1911. 1910, Teddy Roosevelt was also on the grounds giving speeches. And so it's an amazing history that we have in the Omaha legal community. We're celebrating at the Livestock Exchange on March 20th, so I hope you all can make it out to that free reception for the entire Omaha legal community. It's open to all. We're going to have a CLE by our good friend Larry Dwyer, who wrote the book on Standing Bear, and on Andrew Hopkinson, our founder. So if you want some CLE credit, we're just going to do that sprinkled in at the beginning. But if you just want to come for the reception, that's on the later half of the other side of the ballroom, so you don't have to sit in on the CLE. You don't want CLE. I just want to change gears here and say hello. My name is Dave Summers, calling from the campaign office of Fill in the Blank. We'd like to invite you to a reception we're having for a candidate. We're asking $2,000 per attendee, if that's possible, to our campaign funds. A private coffee for a select few will be held after the event. And to be a part of that, we're asking you to bundle together $10,000 at least. Prior to law school, this was my job. I was a political fundraiser for federal campaign officials, or first federal campaigns. So this is what I did day in, day out, prior to going to law school and prior to joining the Omaha legal community. I helped candidates raise money for campaigns. I had candidates ask people directly for money. They spent a lot of time doing it. I spent a lot of time helping them do it. So when Daniel said he wanted to talk about this, I was certainly all on board having that history. I'll talk about my own thoughts on campaign finance at some other time, but I just wanted you to to get a sense of what it was like from somebody on the ground. I know we have some people in the room that are running for office. I know we have people in the room have held um, or are holding public office at a local, state, or federal level. I know that many of you have given to federal campaigns. I know that anybody who has given to federal campaigns are receiving emails, texts every single day, pretty much, asking for more dollars for federal campaigns. I am thrilled to have Daniel speak here. I won't take up any more time. We'll save a little time for Q&A at the end. So excited to ask some questions. We'll do that. And I'll turn over to Daniel Gutman.
Oh. Well, hi, everyone. Thanks, Dave. I didn't know that Professor Fenner did this for 31 years until right now, so I guess I have 29 years to go. The university bureaucracy at Nebraska would also like me to clarify that I am a lowly peon, non-tenure track instructor, so I don't know if I really fit the bill, but I'll give it a try. My name is Daniel Gutman. I kind of wear two hats. I have my own kind of private practice law firm that does a lot of election related work. And then completely separately from that, I direct the First Amendment Clinic at the University of Nebraska College of Law, which is a relatively new clinic. I am here wearing the First Amendment Clinic hat today. I didn't tell Dave I was going to do this, but I actually want to start. I feel like a lot of people don't know what the First Amendment Clinic is, or that Nebraska even has a First Amendment Clinic. And I rarely have an opportunity to stand up and tell people about it. So I want to start by talking about the clinic, and I'm going to go very quickly. This is like my normal dog and pony show, so I could spend an hour just talking about our cases, but I'm going to go very quickly over some of the cases that we have done through the clinic. First, I'll start by saying the clinic we usually have about 8 students. It's myself and an assistant director. We have kind of what I call an academic component where we talk about the First Amendment, but most of our work is just hands-on litigation. It's students working up cases under our direction and using our bar license. And we file cases in state court. We file cases in federal court. We do non-cases. We advise clients separate from litigation on any matter that really touches First Amendment. So, quick overview of some of our cases. This is our first case, Melissa Temple versus the NRD. This was a case involving campaign candidate and an elected official who spoke up on the board and was censured and then also had some privileges taken away. We alleged First Amendment retaliation claims on her behalf. We were successful in that in a preliminary injunction, and one of our claims on the preliminary injunction relating to an elected board's ability to sanction members of that board. Another case. This is the best case, and none of our clinic students did not try a federal criminal case, but this is. Our students did write an amicus brief to the 8th Circuit, and the only way I can explain this case is I don't know if people have seen Terminator 2. I'm sure most people have seen Terminator 2. There's a part in Terminator 2 where Arnold Schwarzenegger and the kid and the mom, they break out of the mental institution and they go to this desert. And there's like a school bus there and there's nothing there. And then all these people with guns emerge out of nowhere and they pull the ground up and there's these cellars with all these guns and ammunition. Mr. Unisek kind of lived on one of those compounds. He really liked guns. He really liked explosives. He did not like federal enforcement agents. And one day, the federal enforcement agents came out and they arrested him. He went to jail, and while he was pending trial, he was ruminating on how much he didn't like the federal agents who arrested him. And he kind of did. There's some video evidence of this. It's kind of talking to his cellmate maybe about the things he wanted to do to the federal agents who arrested him, and he made a couple like weird kind of sword moves, and cutting and stuff like that, and it got back to the federal agents somehow, that this had happened. He would have never have known about it anyway. And there was a recent U.S. Supreme Court case that dealt with um, free speech and threatening speech, and the requisite intent requirement and knowledge requirement that's associated with that. We argued that the jury, so he was ultimately convicted uh, of a threat, and we argued that the jury did not, or that the district court judge did not properly instruct the jury on the proper mens rea requirement, and went up to the Eighth Circuit. None of this was appealed or preserved below, so we didn't really have the winds at our back. The Eighth Circuit ended up affirming the conviction, but in direct response to the student's amicus brief, kind of went on to talk about what the proper standard is, and essentially said, in future cases, we expect for this jury instruction to be different. So that was a really proud moment for the clinic. I'm going to breeze through this one because it is related to our private defamation defense. The clinic, obviously, the First Amendment applies to the government. And so in normal First Amendment cases, you have somebody suing the state government, or you have somebody suing some governmental actor, could be a county or a city or whatever. But the First Amendment is also very much implicated in defamation cases. Defamation cases, in our perspective, are by definition designed to limit speech. I don't like what you said, and I'm going to sue you because you said something I don't like, and I don't want you to say it again. From a First Amendment perspective, we have real problems with defamation cases. So the clinic, and we're part of a sister network of many other clinics across the country, our clinic is very focused on defamation defense. And so we have represented people accused of defamation. Just last week, we won a 50-page district court summary judgment order, won a defamation case. Our clinic students oftentimes do the depositions. They write the discovery. They are very hands-on involved at every step. I saw somebody here that knows this case. We do a lot of court access, or some, I wouldn't say a lot of court access, but some court access. When a lot of time, the seminal First Amendment case at the U.S. Supreme Court was Nebraska Press Association versus Stewart. It dealt with the First Amendment's, the freedom of the press's ability to appear in the courtroom and to report from the courtroom. That's often in conflict with a criminal defendant's Sixth Amendment right to a fair trial, particularly when you're in small towns where the jury is going home at night and reading the coverage and everybody's talking about it. There is a lot of times inherent conflict there. This isn't a huge problem in Nebraska, but occasionally judges will exclude or threaten to exclude the media from criminal proceedings. And when that happens, we have stepped in to try and enforce the media's right to be there. Okay, here's Dave's favorite case. This is a super interesting one that we just filed. This is brand new, so I'll just tell you what's been reported on it. Last week, we filed a case on behalf of the barbershop Blackstone, which is a small kind of hidden bar in the alley of Blackstone. It's directly behind Blackstone Social. It used to be a speakeasy. It's intentionally discreet. It's intentionally hidden. And the owner of it, Mike DiGiacomo, his father ran a salon in the building. And so he grew up sweeping up hair in the building and, being in the presence of beauticians and salons. That was his childhood. So when his dad died, he bought the building. He converted the top to Blackstone Social. We all know Maggie, Blackstone Social. Yeah. And then the basement, he converted into an Italian speakeasy. But earlier this year, he changed concepts and he said, hey, I'm going to honor my father, the legacy of this building. I'm going to open a bar and it's going to call the Barbershop Blackstone. Didn't think anything of it. Hung a barber pole right there. He started getting letters from the Barber Commission, which I didn't know existed, basically saying that state law prohibits anybody, any company, unless you're licensed, from using the title barber or barbershop or from displaying a barber pole. And so they said he had to change his name under threat of criminal and civil penalty. And the clinic's angle here is, and what we've alleged in our complaint, which is on file, is that's a violation of commercial speech rights. Companies have commercial speech rights. They don't often receive the same protection as political speech, for example, which we're going to get to, but they are there. And when the government comes in and says you can't use these words, that can, and we allege does, infringe on the commercial speech rights of people. So this is just a super interesting case and a fascinating story. So we'll see what happens there. Okay, let's turn and talk about why we're here. Dave contacted me. We talked about this like 7 months ago or something. It was a really long time ago. And at the time he called me, he said, "You can talk about whatever you want." And there's this interesting case that's working its way up through the Supreme Court on campaign finance and First Amendment implications of campaign finance. And I said, I want to talk about that case. And so that's why we're here. There's a lot there is a lot that has happened since we came up with this idea to talk about this case. At the time we talked about it, there had not been oral arguments. I thought maybe there would be a decision on it today, but a decision could come at any point. So we're much farther along in the case than when Dave and I initially talked about it. But it's a very interesting case, and again, it deals with federal campaign finance. Couple caveats here. Obviously, there's state campaign finance laws and there are federal campaign finance laws. This presentation, this case has nothing really to do with state campaign finance. This is about federal campaign finance. I am also going to breeze through incredibly consequential U.S. Supreme Court decisions in like 2.5 minutes. So I'm not doing them due justice, and there's way more that we could talk about, but for the sake of time, I'm going to really go quickly. So federal campaign finance laws. What's like the seminal campaign finance case that you think? When I say campaign finance, you think Citizens United, and when you think Citizens United, you think what? Yeah, corporations are people, right? Like that was the tagline after Citizens United was decided. Corporations are people. That's what most people know. Not surprisingly, it's far more complicated than that. So we'll go very quickly through. Some history. Dave, come up here. You're going to be our Senate candidate. Okay. So Dave
Summers.
Hi.
Nice to meet you. Dale, glad to meet you.
Yeah. You look the part. So Dave has decided to run for Senate. He cares about this and that, and he's mad about this and that, and he doesn't like this person or that person. So he's decided to throw his hat in the ring. And if you're going to run for U.S. Senate, you need what? Lots of it. Lots and lots and lots of money. Or, as we free speech people say, you need a lot of free speech. Right? It's just speaking. And so there's different ways that Dave, the candidate, am I getting a echo here? Are we good? Okay. There's lots of ways that Dave, the candidate, can garner support for his campaign. One way that Dave can garner support for his campaign and money is the obvious one. He can pick up the phone, he can call you, and he can say, "Hey, I'm running for Senate. Give me your money into my campaign." Okay? That's a lot of First Amendment transaction under the U.S. Supreme Court. He's calling up, he's asking for money, that's protected. And the person who he calls and asks for that money, if they are giving him money for his campaign, that's also protected First Amendment activity. So that's one way that Dave can raise money for his campaign. Importantly, and we'll talk about this, direct contributions from a person to a candidate are regulated, right? Congress has said, we're going to regulate how much money you can give that person. And so far, the U.S. Supreme Court has said those regulations are A-okay. All right. Another way that Dave can get support for his campaign, and this is really important to the case that we're going to talk about, is what's called coordinated party expenditures. Okay, so what's that? Let's say that Dave's running as a Republican, and he contacts the Republican Senatorial Campaign Committee. This is a committee of people that get together and they say, we want to elect Republicans throughout the country to the United States Senate. We want to raise money to support that mission. And we are going to give money to candidates and we're going to spend money on candidates' behalf. Okay? So the Republican Senatorial Campaign Committee, and there's a Democratic one, I'm sure. I'm not as versed in the yeah. So there's one, there's a Democratic one and a Republican one. They call up rich people all day long and say, give money to our committee, and we will then use that money out in the field. There are regulations that have so far been upheld on how much money those committees can take in. And for a long time, there's been regulations on how that money can be spent. Now, to cue you in on what this case that we're talking about is, and this gets to the next point, independent expenditures, Senate campaign committees can spend money in one of two ways. They can do it in coordination with the candidate, or they can do it independently. Okay, spoiler alert, huge First Amendment debate over what I just said, right? The Senate campaign committee can call Dave and they can say, hey, Dave, we see you're running for Senate. We want to help you. We want to put ads out into the field to help your campaign. How about you tell me what people care about in Nebraska? Who is your biggest vulnerability? Who do you need to get? And Dave might say, oh, I need to get, a quarterback for Nebraska football. Well, that's not what I was thinking, but okay. Yeah, I was thinking that he could tell the committee, I'm really struggling with people ages 21 to 35.
Dream, sure.
Yeah. And it would be really helpful if you could market to them. The fact that he's sharing information about his campaign with the committee makes that a coordinated communication. Okay? And so far, what the rule is, and what Congress has passed, is if you're going to do that, if you're going to coordinate, fine, but you, the committee, can only spend so much money to help him. Right? There's limits on how much I can coordinate with him through my expenditures. But Congress also passed a law that said, well, even if you're not coordinating, even if you're completely independent of the candidate, those are regulated too, right? You can only spend so much money even if you're completely independent of him. Spoiler, as we'll get to, that has been ruled unconstitutional. So for the purposes of this conversation and review of the case law, it's really important to distinguish between coordinated activity and independent activity. Independent activity is activity that happens without any communication, without any involvement, without any winks and nods from the candidate. It's completely independent. And the state of the law,
By my former best friend and former chief of staff who went out on the village 6 months ago.
say that again.
But it can be run by my former chief of staff, who I don't talk to anymore, who was my best friend, who knows me better than anybody.
And what you'll see a lot is people that are really close to campaign, like their chief of staff of some campaign, will go off, they'll quit, and they'll join a super PAC. And, technically now that person's part of a different separated entity.
They're not writing anybody.
They're not talking to anybody. But the long and short of this overview is what the Supreme Court has held is independent expenditures cannot be regulated. And we'll get there. But coordinated communications and coordinated expenditures can be regulated. And that's all through a First Amendment lens.
And on that note, I am going to now run down.
Yeah. Thank you, Dave. Okay. So let's talk through some of the early cases that lead up to the case that we're going to talk about. There's a Colorado 1 and a Colorado 2. I put the formal case names here, but Colorado 1 was a decision, and I actually have two First Amendment students here, Grant Little and Blake Aspen, talented First Amendment students who helped with all of this. Blake, do you have any idea? I'll put you on the spot. When Colorado 1, this is not like I know the answer to it. I'm literally asking. Do you remember when it was decided, like 2001 or something? Okay. So Colorado 1 is 25, 26 years old. Um, this is a case in which the Colorado Republican Party challenged a provision of federal law that capped the amount that political committees could spend even on their own to help a candidate win. So essentially, what this says is the Colorado Republican Party wanted to help a candidate, and they did not want to coordinate with that candidate. They wanted to spend their own money on things that they thought were important, but it would help that candidate. Uncoordinated contributions. At the time, there was a federal law that said you can do that. You can spend your own independent money, but if you do that, there's a cap on how much you can spend. Okay. And so, what the Colorado Republican Party was doing was challenging that component of the law. If we're independent, we shouldn't have restrictions. We should be able to spend whatever we want. That's consistent with the First Amendment. We should be able to speak freely, spend our money, get our ideas out into the marketplace without the government interfering in what we're doing. The U.S. Supreme Court, and again, I'm breezing past this, but the U.S. Supreme Court agreed with that decision. And this is really a focal point in when the Supreme Court starts distinguishing between coordinated activities and what are called independent expenditures. And what the Supreme Court says is that when a party spends its own money completely independent of a candidate, it is engaging in core First Amendment activity. And it looks at the government interest and it says, okay, well, if you're going to infringe on that core government, on that core First Amendment right, the state or the Congress in this case has to come up with a compelling interest as to why they want to infringe on it. And the Supreme Court says there is no compelling interest. If the candidate and the spender are separate and they are independent of each other, there is no compelling interest as to why the government should interfere in that right. And so they strike that provision of the law down. And the effect of it is that political committees can now go out and they can raise a bunch of money from people all over the country. And if their communication, if they're not coordinated with the candidate, they can spend as much as they want to help a particular candidate run and get elected. Okay, we good on that? All right. Next case is Colorado 2. So basically, the Supreme Court remands and it comes back up. So Colorado 2 is different than Colorado 1. Let me put this back here. Colorado 2 is different than Colorado 1 in that the Republican Party comes back up and says, well, you invalidated the first thing that we were mad about, which is independent expenditures. Thank you for that. But we're also kind of mad about the coordinated one too. Like, we should be able to coordinate with our candidates and talk to our candidates and figure out what's important in their communities and spend as much money as we want to help them get elected. So it comes back up to the Supreme Court on those grounds. And the Supreme Court says no. They say, when you're coordinating with a candidate, that's fundamentally different than when you're acting independently from that candidate. And so Congress can regulate coordinated activity in a way that they cannot regulate independent activity. Let me stop here. This is what I do in click. Does this kind of make sense here? Have I lost her? Okay. So that's the distinction that they make. And one of the justifications that they're worried about here is quid pro quo corruption, which is going to come up in Citizens United, right? The thought is, hey, when you're given to a candidate, when you're either giving money directly to a candidate or you're spending in coordination with that candidate, there's this aura, this possibility, this thought that donors can stockpile money and have a quid pro quo relationship with a candidate, right? I'm going to go support you. I'm going to go spend a bunch of money for you, Dave. We're going to spend tons of money for you, and I'm going to go get that money from a bunch of individual donors. And hey, can you, when you're elected, can you help us out on this matter, right? Quid pro quo corruption is what the Supreme Court was worried about with respect to coordinated activities. And that's what they say is a core principle and a justifiable state interest. And they say, and we'll get to this with Citizens United, when you have independent expenditures, that possibility of quid pro quo corruption isn't there because they're not coordinated, right? They're completely separate. Now, we can debate whether that practically makes sense, but you can come to your own conclusions. Okay, so that's Colorado 2. Another spoiler alert, the case that we're here to talk about is basically asking a reversal of this. Then we get to Citizens United. Again, this was big, obviously a very, very big case in the campaign finance world. Essentially, the facts of the case, Blake could probably recite them better than I can at this point, but there was a group called Citizens United, and they did not much like Hillary Clinton. And what they wanted to do, they created this documentary about Hillary Clinton, and they wanted to disseminate it. They basically wanted to make it available to the public. Am I doing this justice, Blake? Thank you. They wanted to disseminate it and make it available to the public. But there was a provision of federal law that said corporations cannot use their own money to engage in electioneering activity, particularly within a certain time frame before an election. And I can't remember exactly what the time frame was, but something like 2 weeks before an election, the regulations get super tight. Okay, and it's the law was BICRA, which is the Bipartisan Campaign Reform Act, prohibited corporations from using general treasury funds to make direct or indirect, that's the important part, or indirect expenditures that expressly advocate the election or defeat of a candidate. This was just a flat out prohibition. If you were a corporation and you had general money, you didn't have set up some separate segregated fund, you just had money that you wanted to spend to support somebody, you just couldn't do it. And there was criminal penalties associated with noncompliance. And so what Citizens United did is they focused on the independent expenditure prohibition. They weren't as interested in the direct contributions to candidates. What they said is, we are a corporation, and you, the Supreme Court, have said that corporations have free speech rights, and you claim to value corporations speaking, educating the public, getting ideas out there, debate, all the things that come along with the First Amendment. You have said that you appreciate those. And you said in Colorado 1 that independent expenditures are completely different than coordinated expenditures. Well, all we're trying to do is make independent expenditures in support of a candidate. We're not coordinating with them. You said that was fine in Colorado 1. Why can't we do it? If we do it, we're all of a sudden going to get arrested? That was their argument, right? And so the U.S. Supreme Court, it goes up, and the U.S. Supreme Court rules in favor of Citizens United. And again, it was kind of this bombshell opinion because, the thought is that there was going to be a bunch of corporate money in politics, whereas before it was outlawed. And I think that was ultimate. I think everybody would agree that there is more money, corporate money in politics because of that decision. You can debate whether that's a good or a bad thing, but there's no question that this opened a lot of doors for corporations to get involved in elections and to support or oppose candidates. Importantly, though, it's through independent expenditures. So what Citizens United holds is that if a corporation wants to spend its money to support a candidate, it can do that as long as it's independent of the candidate. If they are coordinating with each other, if they're talking with each other, if their campaign staff are calling each other, Dave's friend from his old roommate, if they're doing the whole wink and nod thing, that's not permissible. It has to be completely independent in order to gain maximum First Amendment protections. And so the takeaway from Citizens United, there's a couple. One is corporations can spend their money directly and freely as long as it's an independent expenditure. And that's why when you turn on your TV and you see paid for by the, you know, whatever pack or paid for by Nebraskans who support blah, 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 chances are that is a corporation that has amassed a large amount of money and they are running independent expenditures either in support or opposition of a candidate. And presumably they have no communication with the candidate. They're doing it on their own polling. Dave, you look skeptical. No, not at all. Okay. Um, Here's the other really important part of Citizens United. The Supreme Court doubles down on this notion that that basically first, spending money, contributions, money itself is core First Amendment activity. I mean, as the years have gone on, that principle has gotten stronger and stronger. That ain't going anywhere, right? Money in politics is free speech. I mean, that's just the way it is. So that doesn't mean that the government can never infringe. I mean, it's just like any other constitutional right. The government can sometimes infringe on those rights if it meets certain standards, if it meets certain levels of scrutiny. And what the Supreme Court says in Citizens United, which often gets lost in the holding when people are just saying, like, oh, corporations are people, there's a subset of the decision that's really important. And that is the Supreme Court says that the government's only interest in regulating campaign contributions and expenditures is eliminating quid pro quo corruption or the appearance of quid pro quo corruption. So if the state imposes some sort of a limit on your ability to give money, it needs to fall within that justification. They need to tie their limitation on your ability to spend money to that governmental interest. Elimination of quid pro quo corruption or the appearance of quid pro quo corruption. The other thing that they have said in subsequent cases is just saying those words is not enough, right? The government can't just say, oh, yeah, we read that we're supposed to say quid pro quo corruption, so we're going to say it, right? They have to have actual evidence that quid pro quo corruption is happening or the appearance of it is happening. So they have to assert that interest and provide evidence that that is a real concern. That's really important. I mean, because it significantly curtails Congress's and states' ability to regulate money in politics. So, and again, one last point on Citizens United. Independent expenditures, according to the Supreme Court, never give that appearance. So if a state or Congress wants to, essentially can never, under the current regime, pass a law that says, hey, we know that you guys make all these independent expenditures. You can only donate $3,000 towards that. No, what the Supreme Court has said is the only thing that justifies a restriction is quid pro quo corruption or the appearance of it, and independent expenditures never fit that bill. So it's wide open for independent expenditures. All right. So here's our refresher before we get to the case. Political committees can make unlimited independent expenditures in support of candidates. That's Colorado 1. But restrictions on coordination between political committees and candidates are constitutional. Congress may not restrict independent corporate speech. Keyword there is independent, uncoordinated. The only permissible campaign finance restriction is elimination of quid pro quo corruption. That's also Citizens United. So the Republican Party really appears a lot in these, although the Democratic Party is aligned with them every time, except for this case, actually. So don't just because the Republican Party is in the caption of all these cases doesn't mean that it's not a bipartisan position. So this is a really interesting case in my view, for a number of reasons. We talked about Colorado 2. Colorado 2 was the case where the Colorado Republican Party said, look, we should be able to coordinate with the candidate and make expenditures for that candidate. And you, Congress, should not be able to interfere or cap how much we can spend in support of that candidate. And the US Supreme Court said, no, too bad. Coordination's different. We can restrict it. So this case, frankly, comes up almost on the same issue, right? There has been things that have changed. One obvious change is the composition of the court. I think Justice Thomas is the only person left from Colorado 2 who's now on the court. And guess what? Justice Thomas dissented in Colorado 2. So we know his position on this issue. So the composition of the court has changed. There's also been some tweaks to federal law since Colorado 2. So there were some tweaks in 2014. Interestingly, I think I learned in like high school government that, those who make the rules make them for themselves, and oftentimes lawyers are the ones that make the rules. They passed this amendment in 2014 that basically says, oh yeah, all that coordination limits, all that stuff, that doesn't apply to when you're paying lawyers, right? So you all rest assured, you're fine. They can pay you whatever you want. So there has been some tweaks. There is a different composition of the court, but beyond that, this is essentially a materially identical case to Colorado 2. There's some interesting nuances to this case. One is the plaintiff. This case came up in 2022 under then Senator J.D. Vance. J.D. Vance and anybody know this guy? Shabbat? Steve Shabbat are the plaintiffs along with the NRSC. The reason why this is relevant is because a component of the case is justiciability. The congressman retired. He's already said, I'm not running again. This was a very live controversy when J.D. Vance was a senator because he said, I'm going to run for Senate again. And I want to be able to coordinate and not have these limits. Well, of course, after this case gets up there, he becomes vice president. So the other side is arguing, well, you can't even reach the merits of this case. J.D. Vance responds and says, interestingly, what he has to say, which is, I haven't decided whether I'm running for president. I have a live Senate campaign with 50 grand in it, and that keeps this case alive. I think that they're going to reach the merits of this case. I don't think that they're going to duck it based on justiciability. So I think that argument will probably win the day. But it's just kind of an interesting note that J.D. Vance is the plaintiff in this case, but not J.D. Vance as vice president, J.D. Vance as Senate candidate. So the other interesting thing about this case is you'll see that the named defendant is the Federal Election Commission. The Federal Election Commission does not defend this law. They have said, no, we agree with J.D. Vance, right? Which is not unheard of. I mean, this happens sometimes in court cases. And, basically at that point, the Supreme Court has to bring somebody else in to defend the position of the other side. But the FEC is fully aligned with the plaintiffs in this case. And so, another interesting wrinkle there. And the issue is exactly what the issue was in Colorado too, whether the limits on coordinated party expenditures violate the First Amendment, either on their face or as applied to party spending in connection with party coordinated communications. What that means in real people talk is the Republican Senate Campaign Committee wants to run communications. They want to run ads for J.D. Vance's Senate campaign. They want to be able to call J.D. Vance and they want to be able to say to him, hey, who should we target in these ads? Where should we run these ads? What would you like that messaging to be? Under current law, they can't do that because if they do that, there's hard restrictions on how much money they can spend, and they don't want those restrictions there anymore. That is the essence of this case, right? So it was argued December 9th, and it's awaiting a decision. Oh, yeah, well. So why is this important? I think it's important for a few reasons. One theme at oral argument was all of these campaign restrictions on parties have really weakened parties, right? A political party or committee's ability to raise money is hampered by the fact that they have restrictions on how much money can come in the door. And then once it comes in the door, there's restrictions on how much can go out the door if they are coordinating with the candidate. And so they're kind of throwing their hands up and saying, I mean, they're not saying this, but we're no longer relevant, right? We're losing out to all these super PACs who can raise unlimited amount of money and spend unlimited amount of money. All the rich people want to go to the super PACs instead of coming to us because we have all these restrictions. And that comes out in the argument. You might be asking yourself, as one of the justices did, like, why is that relevant to us? That seems like more of a policy concern. And the response is, well, parties are really mediating sources. They're not as extreme as the super PACs, and so we need more money to moderate the message. And I don't know if that's going to go anywhere, but that's an argument they make. It also just doubles down on the first notion, which the Supreme Court keeps getting stronger and stronger on, which is, what are the free speech rights of people taking in and expending funds, right? I think that this case, assuming the court reaches the merits, is just going to reaffirm the First Amendment protections that come with money in politics. Relatedly, this kind of goes to the second point, how information and ideas are transmitted. Again, a central argument in this case is that we cannot convey our message effectively because of Congress's limitations on our ability to spend money. We'll see if that wins the day. Another huge one is the possible erosion between coordinated and independent expenditures. I've spent most of my time trying to distinguish between a coordinated effort, which can be regulated, and an independent effort, which cannot be regulated. Clearly, the First Amendment lawyers who are representing parties on this, they do not like that distinction. They would like to erode and eventually eliminate that distinction. And they would like the rule to be, there is no difference between the two, right? This case is not going to answer that question. It's not going to go that far because it doesn't present that far-reaching of a question. But one of the sides is arguing it's just a matter of time, court. They're really just trying to erode all the protections and just leave it completely wide open. Again, I don't know. Last thing, what is the Republican Party's primary argument in this case? It's this: the only permissible regulation on campaign speech is quid pro quo corruption or the appearance of quid pro quo corruption. Okay? The Republican Party is arguing, and I think this argument makes a lot of sense. You can disagree with me. Their primary argument is, look, if Joe Blow off the street offers Dave Summers, who's running for Senate, $1 million, there's potentially there's at least maybe the appearance of quid pro quo corruption there. Random guy off the street giving Dave a whole bunch of money, probably wants something in return. We're the Republican senatorial committee. Like, we only exist to elect Republicans to the Senate. There is no realistic possibility of quid pro quo corruption between us, who exist to elect these people, and the people we exist to elect, right? So they're trying to distinguish here and say, yeah, maybe quid pro quo applies at some other place, but certainly not to us, right? And you, court, have said quid pro quo corruption is the only justifiable response, and that Congress has to provide evidence of the quid pro quo corruption or potential for it. Here, there is no possibility for quid pro quo corruption. And even if there was, Congress has no evidence that this has actually resulted in that corruption. So we win. The counter to that argument is, well, really what happens here is the Republican Senatorial Campaign Committee goes out and solicits a ton of donations from wealthy people. They bundled cash. And then they funnel that cash and if there's no restrictions, they'll do it even more. They'll funnel that cash to a particular race. And maybe I guess they'll say, "Oh, by the way, we received all this money from all these rich people." So they're like an intermediary maybe between the quid pro quo corruption. I think that that's the argument. It seems a little attenuated. I don't know if that's going to win the day, but that's a brief summary of kind of what the other side is saying. So I think in terms of where this leaves us, obviously I have no idea. Um, I hate when people are, "Oh, I think the Supreme Court's going to." I mean, I had no idea. But what most observers would say, people involved in these cases, is there is a high likelihood that the Supreme Court will eliminate the restrictions on coordinated communications between political committees and certain federal candidates. Again, other restrictions on independent expenditure or on coordinated activity would still apply, but that one would fall if the Supreme Court uh, ruled that way. So we'll see. I think a decision could probably come any day. And if it does rule that way, I think you're going to see a lot more coordination. You're going to see a lot more money, a lot more ads. And again, I think people can debate whether that's a good or a bad thing, but that's just the reality of it. Okay, I'll stop, and then we have a little bit of time for questions. Yes, Dave. All right. Well, I don't know in the context of this case. I know in Colorado too, the way that it got up to the Supreme Court, the way that it happened is the Colorado Democratic Party said to the FEC, look, they've already reached their cap and they're about to run another ad in coordination with the Republican Party. And so they went to the FEC in that case, and the FEC is the one that enforced it and sent them a threatening letter. That was the procedural posture in which it got up. But yeah, I mean, I have no idea who actually shows or enforces the quid pro quo component. Yes.
I've always been curious. Sure.
Oh no, I didn't. I promise, I really didn't. No.
Um, us, well, edit. Then eight, make it careful. So you're down 50 summer, and they were Lucy. Yeah, baby, didn't know you. And some girls, so, yeah, gun. Oh,
Yeah. It really brings me back.
is it boring? But I just don't like this group. After then they called at and they some of right. Did that would destroy that all independent donation and you think that would
I've never seen that hypothetical like in a case. I've never seen that in a case, for example, but that would feel to me just on gut instinct if Dave, the candidate, is calling up an independent expenditure group who's supporting him and saying, "Hey, I really don't like that. You need to take that down." And they're being responsive to that feedback. That feels like coordination. Um, yeah, I mean, I have seen. I don't. These guys are more politicos than I am, but I have seen instances where candidates have disclaimed independent expenditures in support of them. And I'm blanking on, there was one local one here recently. Oh, actually, it was in our city council. But somebody made an independent expenditure for the city council person, and he came out and disclaimed it. I mean, certainly he could come out and disclaim it. That's not coordination. But I think if he's calling them up and saying, I want you to take it down because it's hurting my campaign or something, that probably blurs the line, um, and could get the candidate in some trouble and the independent expenditure group.
Just to follow up on her question, I think with it United independent expenditures, super PACs that are able to spend however much they want and come up. Typically, the ads have gotten dirtier. That all has happened, but kind of to combine the two facets of what you talked about, what the First Amendment does. Could you foresee, or have you ever come across a case where a candidate maybe filed a defamation claim based on some of the independent expenditure ads that go again, similar to what she says, they got over the street into the quad, sleeping on the street, and things of that nature. When that never happened.
They've evolved.
But I'm just saying, and that's a lie. I put that lie out to the public. Like, combining the things that you talked about, is that an actionable?
Well, there certainly has been defamation claims based on political marketing. I mean, there was one last year, Nebraska Republican Party versus Palm Tag versus Nebraska Republican Party, where Palm Tag was a candidate, and the Nebraska Republican Party put out mailers that, I don't remember all the facts of it, but she said they did not accurately portray her professional history. And I mean, those are hard cases, because if you're subject to the public figure standard, which is a heightened standard under New York Times versus Sullivan, a court's going to look at this as like, look, this is a political public debate. We should allow for some jabs, right? But to answer the question, yes. I mean, a political candidate who has independent expenditures or coordinated or direct expenditures put out against them, they can absolutely sue for defamation. They can, and they do. The claims are hard to win, but certainly can. Yes.
I like they're wanting the electric support lottery. That it's not really that. How is that any different? That up giving? Why should you go to the regular stuff? Let's not pretend that really the corporation. I didn't call it lot, but it's a corporation that matters. Yet, lottery, why they want that? We can go like Solo or any other corporation for he seems like they're no. I agree. See that.
And I think that perfectly encapsulates what the other side was saying, right? Like I think the way that I read the other side's argument is, Supreme Court, you have to keep this distinction between coordinated and independent. Like, that's where you've drawn the line in the sand. You got to maintain it, because it's way more complicated than, oh, well, of course they're doing that, right? Everybody has interests. You got to keep that line in the sand. But that is certainly what the other side's arguing. It's more complicated than that. You know, absolutely. The other big part of this case is the last part that you said, which is this is the domino to fall, right? And again, you can have varying beliefs on whether the domino should fall or not, but that was a central theme in argument. Is justices were asking, no, you're looking to the next thing. You don't even really, maybe don't even really care about this. This is to make sure the domino falls and there is no distinction between coordination and independence. And again, who knows how that's going to come down. All right. Thank you.